So what we've been saying here at the MeidasTouch Network about Judge Eileen Cannon's completely just clogged docket right now and utterly confusing docket based on all of the moves that she made, it's creating a situation where Trump is using that to request more delay in the underlying case. As I've said, Cannon's corruption is matched and exceeded by her incompetence, or both her corruption and incompetence are inextricably intertwined. Her docket in the Mar-a-Lago document case is just such an utter mess. Like, I truly wonder if she's able to keep up with even her own dates and deadlines now, because she's missed dates and deadlines. She hasn't ruled on things. She's held bizarre pre-hearing to pre-hearing to pre-hearings before holding hearings. She's completely butchered what the Classified Information Procedure Act even is. And so now Trump and his lawyers just filed a motion basically saying, look, we need more time, push all the dates and deadlines back because you haven't ruled on this and you haven't ruled on this, and therefore we can't file things, Judge Cannon, until you rule on the things you said you were going to rule on that have been fully briefed. So I guess we're just going to have to push all of the dates and deadlines back. Let me just show you what Trump filed, and let me get into the weeds here with you. We'll legally geek out a little bit, if you will, on what Judge Cannon's been doing or not doing, and I want to explain to you why it's such a mess. So here's what was filed by Trump's lawyers: defendant's motion for an extension of reply deadlines. Trump submits this motion on behalf of all of the defendants for an extension of deadlines for filing certain reply submissions in support of pending pretrial motions. The special counsel's office opposes this request. The current deadline for submitting replies is March 14th, 2024. Pause right there. That's also the date that Judge Cannon set the hearing for these pretrial motions, like Trump's motion to dismiss the indictment under the Presidential Records Act and Trump's motion to dismiss the indictment on the argument that says the indictment is void for vagueness and has constitutional vagueness. Trump's also filed a motion to dismiss the indictment, claiming that the special counsel was unlawfully appointed. Trump's argument regarding the Presidential Records Act, and I'm not making this up, Trump says that presidential records are actually his personal records, our national defense information, our nuclear codes, our war plans, all of our government records, and the most sensitive ones. Trump says when he put them in a box and he shipped them to Mar-a-Lago, they became his own documents so that the government can't ask for them back or can't even question where they should belong, because he put them in a box and shipped them to Mar-a-Lago, and there's no criminal repercussions, Trump states. So Judge Cannon also set the hearing date for March 14th, the same day the reply brief is due. Like, who does... How are you going to read the reply brief if the hearing date's the same as the reply brief? It goes on to say, in anticipation of the March 14th hearing, Trump will file replies in support of the pending motions related to the Presidential Records Act and the Espionage Act on the afternoon of March 13th. The defendants respectfully request permission to file replies relating to the other 24th. Push all these other dates back. The reason for this request are that defendants and counsel need to travel to Fort Pierce prior to March 14th to participate in the hearing, which is time would otherwise be used to prepare the reply submissions. 2, Trump and counsel need to spend time preparing for the oral argument, which is time we would otherwise use to prepare for the reply submissions. Trump and counsel are currently preparing for trial in New York that is scheduled to begin March 25th, 2024, and the need to simultaneously devote attention to that case. And this matter has been necessitated in part by discovery violations, strategic scheduling demands of the special counsel's office that have prejudiced Trump's ability in multiple respects. And 4, on March 12th, counsel for defendant Nauta and De Oliveira are reviewing physical evidence possessed by the office that is potentially relevant to their reply submissions. And 5, defendant Nauta is in the process of conferring with the office regarding access to materials relating to grand jury practices in the District of Columbia that may be relevant to the reply. Defendants have no intention of causing unnecessary delay in these proceedings. Allowing additional time to file reply submissions that meaningfully address the opposition filings by the special counsel's office will contribute to the orderly resolution of pending motions. Moreover, the pending motions for an order regarding the scope of the prosecution team and to compel discovery are relevant to several of the pretrial motions for which additional time is being sought. The resolution of the discovery motions is very likely to require supplemental briefing regarding the pretrial motions. Therefore, we respectfully submit that no actual delay or prejudice to the office would result from the extensions we are seeking. Accordingly, defendants request an extension until March 24th from March 14th to file their reply. And it says, in support of pretrial motions other than those relating to the Presidential Records Act and the Espionage Act. And so let's just be very clear. So Judge Aileen Cannon has not ruled on the motions to compel, which have been fully briefed. Judge Aileen Cannon has not ruled on the government's CIPA Section 4 motion to withhold certain classified information from Donald Trump on the basis of their national security concerns and that they're not relevant and helpful. She had these bizarre round robin type hearings where first you show up, then you show up, then the special counsel shows up, then Trump shows up, then the special counsel's office shows up again. Then there's more briefing. And then she ruled that while Trump cannot receive the actual filings for the CIPA Section 4 submissions by special counsel Jack Smith, she will look after his interests appropriately without him, switch that in a ruling, without him looking at the motions themselves, so that then therefore she will make the determination about whether Trump should see some of this information that the government wants to hold under the Classified Information Procedures Act, Section 4. She has not set a CIPA Section 5 deadline, Classified Information Procedures Act, Section 5, which happens fairly early on in any case involving classified information, which involves when the criminal defendant states the types of documents that they want to introduce that could be classified in nature, and the government files their opposition. That's something that happens early on. She's not ruled on any of that. She's not yet ruled on even this filing by Trump to try to take confidential information that was produced in discovery and publicize it on the public docket. Trump wants to put on the public docket information he received as confidential during discovery, including confidential informants, confidential witnesses, FBI code names, confidential government witness statements that were produced during discovery, which are called Jenks material, which would never be turned over until the actual trial date itself, yet alone published on a public docket. And Trump says the government needs to show a compelling need why that material should not be made public. And the government says that's not what the 11th Circuit said. That's not what any court says. There's a protective order. We produce this confidentially. There's only a good cause standard for us to keep this confidential. In any event, manifest injustice would result if you publicize the names of confidential informants and FBI code names on the public docket. That's just what no court does. And then in hearings that took place last week, Judge Aileen Cannon seemed inclined to allow all that stuff to be made public anyway. And so the short of it is that there are dates and deadlines that she hasn't ruled on. She hasn't ruled on discovery motions. She's setting reply briefs the same day as the oral argument. How are you going to read a reply brief if the oral argument's at the same time that the reply brief is due? I mean, really, it's a mess, her docket, and she's corrupt, but a total mess. And so Trump's looking at this in his file and goes, look, this is all a mess now. Give us 2 more weeks. What's he going to do in 2 weeks? Give us 2 more weeks. That's the whole play here. I want to map it out for you anyway. I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. Let's get to 3 million subscribers together. Thank you for watching.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.